What evidence is needed to prove wrongful termination? Breaking news in the world of labor and employment law. Recently, many individuals have been asking, what evidence is needed to prove wrongful termination? This question is especially relevant as more employees are standing up for their rights. If you have recently lost your job and suspect it was for an illegal reason, you are not alone. Let's break down what you need to gather to support your claim. To prove wrongful termination, you need clear evidence showing that the firing was illegal or violated employment agreements. Feelings of unfairness are not enough. You need solid documentation and witness accounts. Start by collecting your termination letter or notice from your employer. This document should explain the reason for your firing. Next, gather your employment contract, employee handbook, or any company policies that outline the rules for discipline and termination. These materials can be crucial in showing if the employer followed their own procedures. Communications like emails and text messages can also be important. Look for any messages that indicate unfair treatment, discrimination, or retaliation. Witness statements from coworkers or supervisors can strengthen your case as well. If they observed any wrongful conduct or discriminatory behavior, their accounts can be powerful. Performance records are another key piece of evidence. If your employer claims you were terminated due to poor performance, but you have strong performance reviews, this contradicts their claims. Document any complaints you made regarding discrimination, harassment, or safety issues. This shows you were proactive about addressing concerns. Creating a detailed timeline of events leading up to your termination can also help clarify your situation. This timeline should include key dates and actions taken by you or your employer. Understanding federal and state laws is essential too. Federal laws protect against termination based on race, gender, disability, and age. For example, Title VII of the Civil Rights Act and the Americans with Disabilities Act are important protections. State laws may provide additional safeguards. In many cases, filing a complaint with the Equal Employment Opportunity Commission or your state Fair Employment Agency is a required step before you can pursue a lawsuit. If you can show that your employer's stated reason for termination was a pretext, it can significantly support your claim. For instance, if your employer says you were let go for poor performance, but you have documentation showing satisfactory work, this is critical evidence. Similarly, if your employer did not follow their own policies in the termination process, this can bolster your case. Gathering this evidence can be a detailed process, but it is essential for proving wrongful termination. If you believe you have been wrongfully terminated, taking these steps can help you build a strong case.